Welcome back. This video lecture is for study session 3 ACT 215. We are going to be discussing about formation of company. You have learned in study session 2 that a company is a legal entity, distinct and separate from its owner. Hence, there is need to know the procedure and legal requirements for its formation. The legal requirements for incorporation of company are contained in the Company and Allied Matter Act, and Corporate Affairs Commission is in charge with the responsibility of registering company in Nigeria. In this study, we'll be discussing about the requirements for incorporation of companies operating in Nigeria. We will explain the responsibility of Corporate Affairs Commission. We will talk about content of Memorandum of Association. So you are expected to understand them and be able to discuss them at the end of this study. Corporate Affairs Commission is a regulatory body established to regulate the incorporation, running, and winding up of companies, business names, and incorporated trustees in accordance with Company and Allied Matter Act in Nigeria. There are several legal requirements stated by Company and Allied Matter Act of 1990 in section 18 to 40 for the incorporation of new company. These legal requirements include 1. Name of company. The company must have a name which must not be identical with another registered company or offensive. Availability of the company will be confirmed by Corporate Affairs Commission to verify if you can use the name. The second one is registered office address. The company must have a registered business address within Nigeria. The third one is type of company. The law allows for registration of companies for companies limited by share, limited by guarantee, unlimited, and partnership. If your company does not fall on any of these category, it cannot be registered. The next one is share capital. The fifth one is object of the company. That's what the company will be doing per se. The sixth one is director. Those are the people that run the day-to-day management of the company. And the seventh one is subscriber. They are the person that subscribe to memorandum and article of association. They must be adult of over 18 years. They must be of sound mind, and they must have capacity to form a company. They eventually becomes the director of the company in private limited liability company. Before a company is registered by Corporate Affairs Commission, certain documents need to be provided by the promoter of the company to the commission. These documents are contained in section 35 of Company and Allied Matter Act. The documents include 1. A set of memorandum and article of association of the company. The second one, a set of incorporation form containing the notice of registered office address, particulars of directors, statement of authorized share capital, and any other documents required by the commission. The next one is availability of name form showing that the suggested name of the company is available at the commission. The fourth one is statutory statement by a legal practitioner stating that all the requirements of CAMA has been complied with. The fifth one is payment of commission statutory registration fee as required by the commission. The sixth one is payment of stamp duty fee, and the seventh one is any other document that may be required by any relevant law statute. Memorandum of Association is one or two official documents that describe the company constitution. Memorandum of association set out the details of the company existence and it must be signed by the subscriber. Content of memorandum of understanding include the company name, the address of registered office, the object for which the company is formed, statements that the liability of the company member is limited, the amount of authorized share capital and how it is to be divided. And the sixth one is the name of the subscribers. Now, article of association. Article of association is a document that governs the running of the company. For example, it describes the voting rights of shareholder, the conduct of shareholder, directors meeting, and the power of management. The article constitutes a contract between a company and its member, but this applies only to rights of shareholder in their capacity as member of the company. The content of article of association, it includes classes of shares, restriction on the issue of shares, restriction on share transfer, purchase by a company of its own share, how and when directors are appointed. We have come to the end of this study, but before we go, let's do a quick summary of what we have learned so far. We have discussed the meaning of Corporate Affairs Commission. We talked about legal requirements for incorporating a company. We were able to discuss about Memorandum of Association and Article of Association. And finally, we discussed about the content of Memorandum of Association and Article of Association. You can read through your study pack to complement your knowledge about the subject discussed in this video. Thank you for listening. See you in the next class.